Hi everyone. We have a fairly interesting topic here today about the evolution of the right to be forgotten by in the eyes of the judiciary. And our speaker, I have the pleasure of introducing her, Ms. Ruchika Kumar. Uh, Briefly, Ms. Kumar is an advocate and managing associate with an IPR boutique firm, Krishna and Saurashtra Associates, stationed in Mumbai. She holds a postgraduate diploma in global sales and marketing management. She is a commerce graduate from Delhi University and completed her LLB in the year 2002. She has been practicing in the field of trademark and copyright law for almost 20 years now. She has completed an advanced course on intellectual property management and software licensing, including open source from the World Intellectual Property Organization. Her interest in the data privacy regulations drove her to join and complete her postgraduate diploma course in cyber law and cyber forensics at National Law School, Bengaluru last year. Recently, she has been certified as a personal data protection compliance auditor by FDPPI and DNB. Uh, with that, uh, let's start the session. Over to you, Ms. Kumar.
Thank you so much, sir. Thank you for the introduction, and thank you all for taking time out. Everybody is very busy. Everybody has their own lives, and the whole concept of work from home has actually made lives more busy rather than making it easier. So I'm really grateful that you guys have taken time out to attend this session today. I really appreciate it. I consider myself to be a student of law. So I would request the stalwarts here to assist me and correct me if I go off the mark, or if I'm not able to convey, or if my understanding is not to the mark. The topic I've chosen is very close to my heart, and while preparing today's session, I've tried to bring attention to most recent judgments of Indian courts, which have taken a varied view on the scope of right to be forgotten, which is a part of the right to privacy. There are certain issues which are not in debate anymore. For example, that right to privacy is a part of the fundamental right guaranteed under Article 21. It is enshrined in the right to life and liberty. Most of us are aware of the judgment, the Puttaswamy judgment. I will just share my screen and the PPT that I want to. So this is a Puttaswamy judgment everybody is aware of it, or most of you must be aware of it. I will not take time to delve into this. It's a 9-judge constitutional bench judgment. There are certain points which I have enumerated in it, which I thought we could just recap to begin with. Privacy is a constitutionally protected right, but it is not a absolute right. These observations have been made by the constitutional bench in the Puttaswamy judgment. It has also held that invasion of life or personal liberty must meet the threefold requirement of legality, need, and proportionality, which means that there has to be a reason, there has to be a legal reason for invading that privacy. There has to be a need to invade that privacy. There has to be a legitimate reason. There has to be an existence of law, and a proportionality has to be there. So if there is a violation of this right, there has to be the damage which will be caused by allowing this right should be more than the damage which will be caused by curtailing this right. So it has also been observed that it has been held by the court that the fundamental right to privacy has a limitation which has to be identified on case-to-case basis, depending upon the nature of the privacy claims which have been made. Reasonable restrictions can be imposed. I will not be going into the various international judgments or how the international courts and regulations are treating the right to be forgotten, because that is going to be another session altogether. It will take a long time. I will just like to mention that it was observed in the Puttaswamy judgment that right to forgotten, even under the EU regulation, does not mean that all aspects of earlier existence are to be obliterated, because some of those matters, some of those issues may have some social ramification. I will now go to the Article 21 is very, I just like to mention it. It says that no person shall be deprived of his life and personal liberty except according to procedure established by law. The first judgment I would like to mention here, once, is of the Gujarat High Court at Ahmedabad. This was a matter which came up before the court in the year 2015. In this case, the petitioner was accused of various offenses under the Indian Penal Code. The charge sheet was filed and the case was committed to the session court. At the end of the trial, the petitioner came to be acquitted. This judgment was challenged by the state before the Gujarat High Court, and the judgment of the session court was confirmed by the division bench, which became final. The petitioner now wants to migrate to Australia, and he found that the judgment is freely available on the internet, though it is an unreportable judgment. So at the time of passing of the judgment, the court had declared that it is an unreportable judgment. It is not to be reported in any of the law journals. He approached the court stating that judgment is freely available, which is contrary to the classification, and that the same has to be an unreportable judgment. Now, in this case, the court observed that High Court is a court of record, and it also referred to Rule 151 of the Gujarat High Courts, which says that copies of documents in any civil or criminal proceedings and copies of judgments can be provided to the parties. And it also says that it would not be given to persons other than the parties without the order of the assistant registrar, and an application can be made by third parties in accordance of certain set of rules and guidelines which have been prescribed. So in this case, the court held that the judgments which have been passed by this court can be given to third parties. It is something which is available freely. And the petitioner is not able to point out any provision of law under which this petition can be a relief can be granted under this petition. And it was also held that there is no violation to Article 21 of the Constitution, as the judgment is a part of the proceeding, and merely publishing the same on the website would not amount to the same being reported. Now, this is one aspect which I don't agree with the court on, that even the court was of the observation that if a judgment is not reported in a law journal, it is not reported per se. So if it is just available on a website, it is not a reporting of the judgment. But I think in today's scenario, we need to look at it in a more open view. Even if it is published on a website or on a third party portal, it is not a law journal that has reported it. It will still amount to being reported. However, I do agree that because it is a judgment which is freely available, it cannot be now taken out of the public domain and said that it cannot be it can be made private. Another judgment which was passed in the same month is of the Karnataka High Court. The facts of this case are very different from the case that we have earlier discussed. In the matter of Vasunathan versus Registrar General, the daughter of the petitioner had filed an FIR under various sections of IPC. Now, she had also instituted and she also instituted a suit before the City Civil Judge Bangalore, seeking a declaration that there was no marriage between her and the defendant, and the marriage certificate has to be annulled. So the parties ultimately entered into a compromise. Suit was decreed, and it was one of the terms of the compromise was that the daughter of the petitioner in Vasunathan, so daughter of Vasunathan, would withdraw the criminal case, and she would request the police to close the case, withdraw her complaint and request the police to close the case. So pursuant to the said decree, the accused in the criminal case preferred a petition before the Karnataka High Court with showing the daughter of Vasunathan as one of the defendants. So her name and address was appearing as one of the defendants in the case. And thereafter, this matter was the proceedings were quashed, Now, the apprehension of Vasunathan's daughter is that if a Google search is conducted, this order will be reflected and it will have repercussions on her public life, on her personal life. So a special request was made to the registry to mask her name in the cause title of the order passed in the petition filed by her husband. Further, it was requested that if her name is reflected anywhere in the body of the order, the registry shall take steps to mask her name before releasing the order. It was also clarified that no such steps will be taken in case of the website of the High Court or when a certified copy of the order is issued to the third party, to a third party or the parties too. So anybody who applies for a certified copy, there will be no masking of the name of the petitioner and there will be no change to the Honorable Court has held in this case that it should be the endeavor of the registry to ensure that any internet search made in the public domain ought not reflect the petitioner's daughter's name in the cause title of the order or in the body of the order. So in this case, a relief was granted, a partial relief, I would say, was granted, where there was no change made in the records of the High Court being a court of record as per Article 215 of the Constitution. So there was no change made to the records of the High Court per se, and anybody who would take a certified copy of the records of the High Court would get the correct, there will be no change in that. There will be no masking of the name. However, when it came to a public platform like a search engine or an internet search, then this order would be in operation and masking has to be endeavored. This is, it did not order it, they said you endeavor to do it. So I feel that the court was understood that it is not as easy to, when if I order that delete this, it is not as easy in factual circumstances to do so, especially when something is already on the internet. So an endeavor is to be made, but it is not a direction to be followed. The next judgment I want to go for is those passed by the Delhi High Court. Now, these judgments of Delhi High Court have been widely circulated. They're published in various news articles. I have not come across most of the other judgments so widely advertised or so widely publicized as I have the Delhi High Court ones. Though both these orders which I will be referring to here are interim orders. They are not final judgments. So the facts are different in both the cases. An interim relief has been granted in both the cases by the Delhi High Court. Now, the first judgment is Zulfikar Rahman Khan versus Quintillion Business Media Private Limited. In this case, a suit was filed by the plaintiff seeking permanent injunction against publication and republication of 2 articles printed against the plaintiff on the basis of harassment complaints claimed to have been received by defendants as part of the Me Too campaign. The individuals who made these allegations against the plaintiff remained anonymous. It is the grievance of the plaintiff that he ought to have been given sufficient notice prior to the publication, and by not doing so, the defendants have published a one-sided account, which has led to tarnishing of his reputation. The Honorable High Court restrained republication of these articles in question during the pendency of the suit. So the first publication that had published these articles already removed it pending the suit. They gave an undertaking of their own volition that they will remove it. However, these articles which were first published by one publication were picked up by another publication and republished. So that republication was restrained, and the plaintiff was permitted to communicate this interim order to any print or electronic platform which they come across that has republished this article. They permitted the plaintiff to approach the grievance officers of the electronic platforms and portals to ensure immediate compliance. And in case the compliance does not happen, then the plaintiff was given liberty to approach the court. So this is an interim order. So till the next date of hearing, this is the order in operation. The second judgment of Delhi High Court is more recent. It is of this year itself. This has again been very highly publicized. I am sure most of you or all of you must have come across this judgment in any article based on this judgment in any of the news publications. It was everywhere. In this matter, a case was lodged under the Narcotics, Drugs and Psychotropic Substances Act against an American citizen of Indian origin in the year 2009. He was acquitted by the trial court. An appeal was filed challenging this order, and a single judge of Delhi High Court upheld his acquittal. The petitioner contended that the judgment of his acquittal is available on Google search to any prospective employer who wants to conduct a background verification before hiring him. Due to these judgments being available on the World Wide Web, he is not getting any employment to his expectation, in spite of being acquitted. I would like to point it out here that he is not getting any employment to his expectation, which again is a very I may expect something, you may expect something, the other person may think my expectations are way beyond what I deserve. So though I will not get into that debate. The appellant in this case then sent a legal notice to the respondents. Respondents were the Union of India, Google India Private Limited, Google LLC US, India Kanun, and vlex.in. The vlex.in removed the judgment, though the other platforms did not remove it. So then he approached the court the issue before them before the court required examination of right to privacy on one hand and right to information of the public records and maintenance of transparency of judicial records on the other hand. The court referred to the Puttaswamy judgment as well as the order in Zulfikar versus Quillinton and the judgment of High Court of Orissa, which I will discuss next after this. Thereafter, an interim order was passed pending disposal of the suit, directing Google India and Google LLC to remove the judgment in question from their search results, and also directing Indian Kanun to block the said judgment from being accessed by using search engines. This matter was to be listed on 20th August. I'm not aware of what transpired during the hearing of 20th August. If somebody can throw a light on it, I will really appreciate that. The next judgment is, like I said, passed by the High Court of Orissa in Subhranshu Raut versus State of Odisha. This matter actually pertained to a bail application, and the Honorable Court examined the aspects and applicability of the right to privacy and right to be forgotten, including delving into the international law with respect thereto. They have made certain observations. There's no order per se passed, but certain observations which have been made are maybe something which we can read about and be aware of. The facts in this case was that the petitioner as well as the accused were village mates and classmates. One day, the petitioner went to the house of the informant, taking advantage of the fact that she was alone. He committed rape and he recorded the gruesome episode in his mobile phone. When the informant warned the petitioner that she would apprise her parents, he threatened to kill her as well as to make the said photos viral. So when she narrated the incident to the parents, he made good on his threat, opened a fake Facebook ID in the name of the informant herself, uploaded the objectionable photos using the fake ID. She filed a complaint with a lot of difficulty, got an FIR lodged. With the intervention of the police, after some days, the petitioner deleted the objectionable content from Facebook. The court made an observation which hits the nail on the head, in this case. It was observed by the court that the information in public domain is like a toothpaste. Once it is out of the tube, one can't get it back in. And once the information is in the public domain, it will never go away. That is a factual position. That is a procedural thing, which when we say the right to erase, the right to be forgotten, saying that it should be forgotten, saying that it should be erased is one aspect, but actually getting it done, implementing it, is something which is easier said than done. It was further observed that though a strong penal action is prescribed against the accused under the Indian criminal justice system for heinous crimes, there is no mechanism available with respect to the right of the victim to get the objectionable photographs deleted from the server of the Facebook, and the rights of the victim to her privacy, which is intricately linked to her right to get deleted, has been left unresolved. It was observed that there is no statute in India that provides for the right to be forgotten. This is again a proposition which has been spoken about by most courts. that there is no statute per se, no legal provision per se, which talks about right to be forgotten at this stage at this point in time. The court also referred to certain recitals and articles of EU GDPR, and the judgments passed by Wales High Court in England, as well as certain judgments of European Court of Justice, as well as the Puttaswamy judgment. It was then observed that if right to forgotten is not recognized in matters like the present one, any accused will outrage the modesty of a woman, misuse the same in cyberspace unhindered, and this will be contrary to the larger interest of the protection of women against exploitation. It was further observed that as the right of the victim to get those uploaded photos, videos erased from Facebook server still remains unaddressed for want of appropriate legislation. However, allowing such objectionable photos and videos to remain on social media without the consent of women is an affront on the woman's modesty. So, and the court said that you may seek appropriate orders against the for erasure of those photos from public platform. The court refused bail in this case. There was, like I said, because the issue was not about right to be forgotten, so no substantial order was passed with respect to that right to be forgotten or right to delete those photographs. Though I do not agree that the right of victim to get those photos, videos erased from Facebook server remains unaddressed for want of legislation, relief in such cases, I feel, can be claimed under Section 67A, read with Section 85 of the IT Act, and also Section 292 of IPC. So maybe on that part, I do not agree with what has been stated. But yes, where the court recognized that in certain cases where women are the victims, something like an eraser or something like removal of those photographs may be a step in the right direction. Now, coming to certain judgments which have been passed in this year, there is, I have already discussed the matter of Zorawar Singh versus Union of India, in which the interim order was passed by the Delhi High Court, ordering Google to remove the judgments and Indian Kanun to block the same from being accessed by search engine. There are two more judgments I would like to discuss. The first one was passed by the Honorable High Court of Kerala. In this matter, you will notice that the name of the appellant is XXX. So the name of the petitioner has been anonymized, and the title it has been ordered by the court that the title will not mention the name of the petitioner. The facts of this case is that the petitioner had filed a writ before this court in 2015 for consideration of her application for contracting marriage under the Special Marriages Act. This petition was allowed, but the marriage was not solemnized due to difference of opinion between the parties. The grievance of the petitioner is that the judgment in the matter published in Indian Kanun and was published in Indian Kanun and indexed by Google. So when a search is conducted using the name of petitioner as keyword, the web page of Indian Kanun showing the judgment appears in the search results. Due to this, the marriage prospects of the petitioner have become bleak. She is victimized by friends and families. So she has requested that her name be disguised or masked or anonymized in that writ which was filed in 2015. The petitioner approached this court. The reliefs that she sought was against Google Inc., US, Google India, and the Registrar General was also impleaded as one of the respondents. So Google India in this case contended that it is neither the creator, nor the uploader, nor publisher of any judgment uploaded by India Kanun. Neither do they own or control any of the search engines, Google search engine, or any search results appearing on it, or any third party to which the search result may relate. So they kind of washed their hands and they said everything in Google search engine is provided, managed, administered by Google LLC, which is a company incorporated under the laws of US. So no relief can be sought against Google India. So in this case, the court referred to observations made in R.R. Gopal versus State of Tamil Nadu. Now, it is again will not be possible for me to go into details into that judgment. I would just like to mention a couple of things which have been observed in R.R. Gopal versus State of Tamil Nadu. In that particular matter, the court had observed that once a matter becomes a matter of public record, the right to privacy no longer subsists. Secondly, it was also held that there is no law empowering the state or its officials to prohibit or to impose a prior restraint upon press and media. Again, Puttaswamy judgment being the cradle of all legal pronouncements with regard to right to privacy, that judgment was relied upon. And the Kerala High Court then held that the rule to be let alone is subject to exceptions, that any publication becomes unobjectionable if such publication is based upon public records, including court records. So any court record is a public record. So, and whatever is a public record cannot be then made private. This is for the reason that once a matter becomes a matter of public record, right to privacy no longer subsists, and it becomes a legitimate right for comment by press and media, among others. It was further observed that concept right to be forgotten is alien to the existing regulatory regime existing in India. The PDP bill was referred to, the proposed PDP bill, and they said that so far it is still not. I will mention the PDP bill as well, the provision that talks about right to be forgotten. They said so far it is not in operation. So unless and until that happens, there is the right to be forgotten is not in existence. However, it was brought to the notice of the court that a similar matter is pending before the division bench of Kerala High Court. So then they decided to adjourn this matter to be heard and determined by the division bench. In the interim, the court registry has been asked by the court, by the learned judge, address of the petitioner in this order. So there is no substantial order per se passed in this matter. There are certain observations which have been made. So we still have to see how the courts are going to be, how the division bench of Kerala High Court deals with this issue. The last judgment I want to refer to today is quite a recent one. It's hardly a month old. This is the one which is passed by the High Court of Madras. Surprisingly, I haven't seen any mention of this judgment on any social media or any news articles. So, though this is the final judgment passed in a writ. In this case, proceedings were initiated against the petitioner under section 376 and 417 of IPC. This is again punishment for rape and cheating. The petitioner was convicted and sentenced by the trial court. Appeal was sought before the Madras High Court. Petitioner was acquitted from all charges, and he is no longer identified as an accused in the eyes of law. So even though he has been acquitted, his name gets reflected in the judgment, and whoever types his name in the search engine is able to access the judgment of this court. In the entire judgment, the petitioner is identified as an accused, even though he has been ultimately acquitted from all charges. According to the petitioner, this causes a serious impact on his reputation in the eyes of the society, and therefore he wants his name to be redacted from the judgment of this court. The Honorable Court recognized that since this issue has come up for the first time before the Madras High Court, it is pertinent to understand the various ramifications before passing any detailed judgment, and the court wanted to hear the counsels for the parties as well as the members of the bar. This matter was adjourned. The registrar was also asked to advertise this, to publish this order in various law journals, as well as to the advocates associations and the bar association. On the adjourned date of hearing, the court came to the prima facie view of the court was that an accused is entitled to have their name redacted from the judgment, more particularly those in the public domain. So the court said, came to this conclusion based on their thought process that the background of a person is assessed by everyone by entering into Google search, collecting information, though there is no assurance that the information secured from Google is authentic. Here I would like to mention about Wikipedia. We all use Wikipedia a lot. Most of the people that I interact with are not aware that Wikipedia can be edited. So anybody can go to the source code, and edit the information. but people rely on Wikipedia a lot. I myself do a lot of research on Wikipedia, though I do it keeping in mind that it may not be all true. So that being said, yes, a lot of there is no assurance that the information that we secure from Google or from search engines is authentic. But this information creates a first impression, and depending upon the data that it provides, it can make or break the character of a person in the eyes of the society. Applying the essence of Puttaswamy judgment, prima facie case is made in favor of the petitioner in view of the court, and he is entitled for redacting his name from the judgment pass. Initially, this court was inclined towards right to privacy, right of reputation, right to live with dignity, being read to have a very wide scope. However, on deeper review, it was observed that this issue was not as simple and straight as it sounded. Till now, the legislature has enacted laws protecting identity of victims who are women and children, and their names are not reflected in orders passed by the court. This right has not been extended to an accused person who ultimately is acquitted from all charges. Additional questions that arise is that at which level of jurisdiction should the process of redaction be done? Is it at the trial stage, or at the appellate stage, or at the revisional stage, or at the time of the filing of the FIR? And how, in what manner should such redaction, deletion, or anonymization be done in cases which have already been concluded and have become part of the record? Eventually, the court made observations that our country does not have a system like the one which is available in the US, where through a court order, there can be a complete destruction of the entire records of an accused person who is acquitted. It may prove to be counterproductive for a person to get their name erased from a judgment or order to prove their innocence, where there are other materials available in the public domain which pertains to damning their name when the criminal proceedings actually commenced. So if in the final judgment, the name of the accused who has been acquitted by way of this order, his name is being redacted or removed, but there is other information which is available, maybe a trial court order is there, maybe an FIR which is somebody has published on social media. If such a thing is there, then it becomes counterproductive, because the final order of acquittal actually goes in his favor. Another thing which was observed by the court was that public access to judgments of courts is one of the elements of the principle of open justice. Now, open justice is one of the central tenets of the rule of law. It has been established by various judicial pronouncements. It was also observed that administration of justice is a task carried out in public interest. Thus, publication of judgments will be covered by reasonable restrictions to the right of privacy. If you recall, in the Puttaswamy matter, it was held that the right to privacy cannot be exercised where the information data is necessary for exercising the right of freedom of expression and information, and the right and for performance of a task carried out in public interest. So applying the same principle and the exception, the court is of the view that if the publication of a judgment is covered by the reasonable restrictions to the right to privacy. It was also observed that High Court is a court of record and is entitled to preserve the original record in perpetuity. There can be no tampering of the record of a High Court. Again, it was it was observed that there is no statute which recognizes the right to be forgotten. There were some observations concerning the jurisdiction of the bench, which we may not delve into as part of this discussion. Just to mention one, they said the order which was brought to the High Court of Madras was by a corresponding bench, and they said we cannot direct a bench of the same level, so it has to be a lower court only who we can order. So this brings me to the end of the judgments that I wanted to discuss. Now, while I was reading these judgments in preparation of today's sessions, it was my observation that though in certain cases the courts have refused to order deletion, masking, or removal of some information from search engines or from court records, the underlying proposition of law is not in dispute. There is a common understanding that there exists a right to privacy, which is contained in the right to life and liberty guaranteed under Article 21 of the Constitution. This is a settled proposition. None of the courts have disputed it. This fundamental right of privacy is subject to reasonable restrictions. Again, it is not in dispute. Such restrictions can only be imposed in accordance with the procedure established by law, and the limitations to right to privacy are to be identified on case-to-case basis and depending upon the nature of the privacy interest claimed. Keeping in mind the vulnerable sections of society like women and children, reasonable restrictions have been placed on media and press by way of legislations like Hindu Marriage Act, Special Marriage Act, POCSO, Juveniles Justice Acts, etc. And the same have been reinforced by way of judicial pronouncements. Thus, petitions like the ones we are recently seeing a spurt of, in which a person acquitted of an offense or who feels that he has been disparaged, or who may have actually been disparaged by way of an article in the media, seek obliteration of such information about them from search engines, publications, or judicial records, may not be maintainable. There have been references by the courts in such matter to the proposed PDP bill. It is pertinent to note that Section 20 of PDP bill pertains to the right to be forgotten. It states that such right may be enforced only on an order of the adjudicating officer. So it is not a blanket right to be forgotten which has been given, that today I decide that I don't want this particular information to be there, and I can go and apply and it has to be done. There are restrictions which have been placed. There are certain conditions which have been placed on this right to be forgotten even under the PDP bill. Those restrictions are that it can only be enforced on an order of the adjudicating officer, and such order of the adjudicating officer may only be issued if the data principal can show that his right to be forgotten overrides the right to freedom of speech and expression and right to information of any other citizen. The burden of proof has been placed on the data principle. So unless the petitioner is able to show that the balance of convenience is in his favor, he may not be granted any relief under the right to be forgotten. I personally feel that in a case a person feels that certain information which is in public domain or is part of a public record is causing him loss of reputation, he may approach the courts for relief against defamation. But deletion of an information which is already in public domain or part of a public record may not be may not be a step in the right direction. So I've just made a table of has been the stance taken by the various courts when it came to the right to be forgotten. If you will see that there is no definite order which has granted any relief, except for the Delhi High Court order, which has granted interim relief. Again, it is not a final order; it is only during the pendency of the suit. In the case of Karnataka High Court, a partial relief was granted. In that case, again, I feel because it was a woman in question, and it was more with relation to the protecting the modesty of the woman and to safeguard her interest and to not have social repercussions against her, that this relief was granted. Otherwise, though we feel that courts are taking very dissenting views, the more I read about it so far, I feel that the courts they may have granted interim relief, but there is no difference in the view. The courts have been very consistent in saying either that there is no legislature, there is no law per se under which we can grant this relief, or they have considered that whatever is in public domain cannot be taken back, or that the right to information or that the right to be forgotten, the disadvantage caused to the petitioner is when you compare it proportionally, the disadvantage caused to the petitioner is less than what will be caused by removal of this information from the public domain. I would welcome any questions, anything.
Thanks, Ruchika. It was a very interesting talk, and especially seeing all those judgments. Of course, like I also have a couple of thoughts. One is on Wikipedia, which you mentioned. As Navi sir mentioned, I'm doing my research. The first thing that we have been told in college is you can use any reference other than Wikipedia. So because everyone understands that that can be edited and it may not be absolutely true. So that's on that. Secondly, on the court piece, if you see most of the courts, even if they gave some kind of relief, they've all said that the court records will not be tampered. That's because you have to also take care of this double jeopardy element. Because what happens if you wipe out that person's name everywhere, then it tomorrow if he's being charged for the same offense or the same thing again, how will he prove it, or he or she, it is in his or her interest that at least in some place it is there. I thought I'll just tell you one example. I saw Reena's message in the chat box asking that how can a common layman. So I actually came across a like an incident where I had to help one of my very old colleagues. What had happened is, this gentleman who spoke to me, he spoke to me. This happened almost a year or 2 years back, and my association with him was almost 10 years before that. So he was working in a particular company, and then he had left the job and he had gone. He's gone out of India. Actually, he's working out of India. He's from abroad. And after him, there were 3 people who have changed over and taken that same role of his. And the third guy who was there in the queue, he was sent out by that company for whatever activities that he had done. And apparently that activity was also out in public domain. It is not only what happened with this individual, but what this person did with XYZ, etc., was in public domain. So what the newspaper did, the newspaper, start off made a story. Whether they got some data from somewhere or not, that's a different question altogether. But they made a story and said, in this company, people have been going on like this or these kind of activities. So they started off with a guy who went recently, and finally they touched this person who reached out to me, who was the 4th in the queue. So he rang up and asked me, what can I do now? I said, you see, first of all, you have left this company 10 years back. I have my own doubts if anybody in that company is going to even help you. And even if they're helping you, they must be fighting out to, sort of save the skin of the last guy who was left, because that guy is going to cause more reputational damage. So he said, what should I do now? I said, see, it has come out in the print media and also in digital media. I said, print media, you can't do anything. After a month, all those papers will become Mumfali papers. So I said, you have, and this guy was also a very renowned person with a lot of standing. I told him, you straight away call the editor of that print media and tell him that, boss, whatever has come in print media is okay, but I don't want to break your head, because they're getting into an apology mode, you're actually confronting the news guys, then they will come up with proof, it will be mudslinging. I said, you speak to him and tell him, boss, I have left that company 10 years back. Why are you dragging me there? Please remove my name from wherever it is there in digital media. And honestly, that worked, 2 days later, he called me and told me, see, Prakash, please do a search and see whether my name is there anywhere. It was not there. They removed it. So sometimes it works, but I'm sure in all those cases which you mentioned, those guys must have done that, and then they would have taken the next step of going to the court. That's what is my feeling. Yeah.
Yes, in these cases, because Google did not respond or did not comply with the notices, the first step was the notice. Because it didn't happen, these matters came to court. In fact, in one of the matters, Google India said that I have nothing to do with it. I don't have any control. I am not publishing. I am not circulating. I am not managing. It's all done by Google US. So this is where I feel that we really need to have our PDP bill being made into an act. So at least these corporations can be held accountable for what they are doing. So far, there is I deal with a very varied set of people, because when we talk in this forum, we know what is happening. We know how these corporations are misusing the data they are taking and how they are projecting it to be very different to the general public. I am also dealing with that set of general public. Because a lot of my contacts are housewives. I have people who do not have, who may be professionals, but who are not from the cyber, from the IT field or from the cyber field. So they feel that what the government is doing is they're trying to curb the social media. They're trying to stop the voice of individuals, stop the voice of people. And sometimes it becomes very difficult for me to convince them that that is not what they are doing. They are actually misusing what you're giving them, and they're actually in another political party in hiding, which which people are not realizing. So yes, that issue is there, and it's really sad to sometimes see that things which can be handled by these corporations, if rules and regulations would be in place. Again,
you can see the corporations fighting against intermediary rules. So that's
and I
no one wants to be responsible. Yeah.
So I have had this debate with my own friends and certain members of my family that who are very pro Twitter, and they're like, what is the government doing? This is like, and every time now a judgment comes up where fines are imposed on Twitter or Facebook or WhatsApp, and I'm like, see, other countries are also imposing fines. It is not that India is doing something which is
Different.
very different or trying to curb the citizens. They're trying to protect the citizens by these rules. But yeah, the way it is projected by these social media giants is very different from what it is in the fact on ground.
Absolutely. Thanks a lot. Thank you.
So with respect to an unreported judgment is something which has not been published in a law journal. That is an unreported judgment. So in case of a precedence, it does not hold too much of precedence value. It's that is the only issue. It is not that you cannot publish it. It's just that it doesn't have much of a presidential value. So they say it is an unreportable judgment. You can still get a certified
What
copy
is
of
the
the order.
history? What is the history of this order? Because law journals don't create law. Okay, a judgment may create a jurisprudence. Why should we say that if it is published in law journal, it has got some value? If it is not published in law journal, it is another value. So I don't see why court should ever think of anything to say that this should not be reported in law journal. Either it is a judgment on which they themselves don't have the confidence. If they come out in the law journal, the judge will be perhaps criticized. I will look at it that way. So I just want to know the history. Even Rimaya and others also can let me know why did this unreportable kind of a thing came. I understand the other case, that is not being a precedent, but unreportable, I don't see what is the logic for that. Please let me know that.
Sir, I want to intervene over here.
Yeah.
There is no distinction as far as following precedent of reportable or unreportable judgments, because a case law is there where it has been made explicitly clear that even unreported judgment can be used as a reference. It was just to save the space. That was the argument in that particular matter, because previously judgments were published in law journals, and at that time it was means even if you see any judgment whether to be reported in media, yes, not, that is mentioned in that particular order. So it was mentioned in that particular case that due to some of the judgments which judges think have more caliber, that or will be more beneficial, those judgments were more reportable and another judgments were not reportable. But there is no distinction as far as the judiciary value or the judgment value of that particular judgments are concerned, even if it is reportable or unreportable. You can even rely on unreportable judgments and take those particular judgments before court as a citation, and you can rely on that particular judgment. And a case law is there as far as whether unreportable judgment can be cited in court matters.
But if it is
So,
not published, how will the public come to know of it?
no, sir. These are available with court records. Previously, what was the matter that only few privileged law houses were given those particular copies. If you want record, you can ask court registry to get the certified copies of that particular judgment. So only reportable judgments are reported through law journals, and that's why they were widely publicized. As far as unreported judgments are there, if you know the cases, means previously it was not possible, at least now it is possible, that you can search for the case and ask the registry for the certified copies of that particular judgment. So that is the only distinction. Even for most of the things, even Indian Kanun, what madam mentioned,
Yeah.
many courts don't rely on judgments of Indian Kanun. Either it should be reported through AI or SCR or likewise. So there should not be any this sort of distinction, but reportable and unreportable. This is what I understood from one of the judgments. Distinction of reportable and unreportable.
Oh,
And as far as the issue of Delhi High Court matter, it was again adjourned. It was taken on 21st August, and no final order are there. Interim orders are continuing as far as the Bagga matter is concerned. PD, that Narcotics Act matter is concerned.
Yeah.
But what were the observations of Prakash sir regarding double jeopardy? When a final judgment is pronounced, the order of the court is acquitted. When it is acquitted, total clean sheet is given, and when clean sheet is given to that particular person, Now his right to privacy and everything comes into picture, and he certainly has that particular right to remove, because it will not act as a double jeopardy. Because if another matter comes, here it is his acquittal. Dual jeopardy is used when he cannot be tried for same offense twice. Once he is acquitted from that particular offense, that judgment will not help him. Rather, the conviction will be in dual jeopardy, not
Okay.
acquittal. And most of the cases, people want to remove their acquittal, and conviction cannot be removed from
Yeah,
the.
I understand what you said about double jeopardy, but as far as removal is concerned, see, acquittal also is dependent upon the sufficiency or insufficiency of evidence, not necessarily because a person is innocent. In fact, you have seen some judgments in which the judges have said that we don't have evidence and we are that's why not able to take a decision. Am I correct? So that being the case, I think that the courts are wrong in providing this right to forget into judgments, because you are changing history. The history is that this particular person was charged and the narcotics was found in his baggage. The court said in this particular case that under this Narcotics Act, if you want to charge a person, this narcotics should be found on his body, and this was in the luggage. So that was a very silly technical reason on which he was considered as not convictable under a particular section of the Narcotics Act. Now, such a thing, if you bring it under right to forget, we are actually trying to suppress the information that this particular person was found prima facie in possession of the drugs in his booked luggage, and due to various reasons he may not be convicted. That is a different issue. Of course, this particular case has to go to Supreme Court, and then we may have to hear more about that. But my personal worry is that we are stretching this right to forget into areas where it does not belong. Say we cannot say right to privacy is for suppression of a fact. It is a fact that the person was arrested, he was in jail for some time, trial took place, and at the end of the trial, a decision came out. Now that is part of a fact, and I don't think courts should exercise their right to suppress this fact. See, what we are doing in the case of women and other things is different. That is in the case of rape cases and other things, just to prevent further problem to the victim who has survived. Then you have a humanitarian reason. There you say X1, X2 or something like that, and complete the whole process. But in every other case, if we are trying to extend this right to forget, it is a misuse of the provision of privacy, according to me. I don't know whether everybody agrees with that view, but I am not very happy with that. Ruchika, yeah.
Sir, as you said, that the criminal justice system in India is not very foolproof. This observation has been made by the Madras High Court in this Karthik Theodore case, in which the court has observed, I would read out the portion, that this court must take judicial notice of the fact that criminal justice system that is prevalent in this country is far from satisfactory. In various cases involving heinous crimes, this court helplessly passes orders and judgments of acquittal due to slipshod investigation, dishonest witnesses, and lack of any effective witness protection system. This court honestly feels that our criminal justice system is yet to reach such standards where courts can venture to pass orders for redaction of name of an accused person on certain objective criteria prescribed by rules and regulations. Thereafter, they've said that it would be better to wait for Data Protection Act, may provide a objective criteria to deal with such redaction of names of accused persons. However, the PTP bill as it exists as of now has not made any such specific mention of that. What the PTP is saying in Article 20 is that it can only be ordered if there is a balance of convenience which is in favor of the petitioner, and the relief granted to him will not affect the right to information.
Now, the same considerations which the court has to consider, public interest versus the individual person. And as you only pointed out, there is always a relief in terms of defamation.
Yes.
If somebody misuses it and say a person who has been acquitted, if another journal again puts it as if he has been convicted, then that is a case for defamation. That is what I think Prakash was also telling. There is a case for defamation. So when there is a legal relief available to such people, there should be no reason why we should push for this right to forget. And PDPB, of course, conveniently shifts it to the quasi-judicial authority who is the adjudicator. So he has to take a view for that, not the data protection officer. That is a good thing in Indian PDPB. GDPR DPOs sometimes I think will be blindly following the request and will be providing that right to forget without exercising the legitimate interest of the company as well as the legitimate interest of the public. Now, as a member of the public, I would like to know if a person has been charged, acquitted, convicted, or whatever is that, because that person is going to be in the public space for as long as he is alive. So tomorrow he may apply for a job in my company, and I would like to know whether he is the person who has got a track record of a particular this thing. I may be myself a background verification company. You are actually killing my power to make a good background verification by such things. I think it should be opposed. My view is that it should be opposed, and even in the adjudication which comes later on, we should not support that particular kind of a view. Anyway, lawyers are here. You may have a different version of that. I am an in-between lawyer and a technical person and a public activist. Okay. Yeah.
Sir, I also had this question. Is all of this thing predicated upon whether somebody is acquitted or convicted? If you are taking the decision based on that, are we saying that somebody who is convicted does not have some right to privacy, under which right to forget is there? Because
no, I am only saying that fact should not be tampered with. You say this person was convicted, he served the terms, and then afterwards he has come as a reformed person, fine. Or he has been charged, he was acquitted, honorably acquitted, whatever is the thing, that is a fact. Now, suppression of the fact is like people claiming that privacy can be used to be anonymous. A criminal can also say that I want to be anonymous. I will murder somebody, but don't tell who has murdered him. That is not public interest. In my view, it is not public interest. And after all, who are the persons who are claiming that right? Only that minority of the public who are, say, involved in this kind of a situation. Of course, you may say law enforcement is dishonest, there is corruption, and police will file false cases. Those are things which have to be handled under other laws. Like you perhaps charge that policeman for wrongful arrest and building up a case, but don't create a situation where the right to information is itself changed because of this sense of privacy. That is my personal
yeah, I mean, not to disagree, but from what I remember, what is the content of the PDPB, there was no distinction being made as to whether somebody is acquitted or convicted. The right to privacy and everything under that is extended irrespective of whether somebody is convicted or acquitted, right? And the second part was even if somebody is acquitted, is it necessary that he must prove that there is some loss being incurred to him in order that he invoke the right to forget? For example, in one of the cases, somebody said that he was not able to get a job because now that he's been acquitted. So is the right to forget also predicated upon the other part of somebody proving that he's incurring some kind of a loss, whether reputational loss or material loss or whatever?
Right. The PDPB is basically focused on organizations which collect the personal information. Now, judiciary, it actually is a process in the society, and as a part of its process, it happens that this information lands in its lap, and judiciary is in many ways exempted from the rigors of collection, etc. You don't need a consent for collection for judicial purpose or something like that. So there is exemption in terms of collection of the information of the accused or whoever is that. Then the trial undergoes, that becomes a fact of the case. Then the question of disclosure comes. Now, this disclosure is not like a company's disclosure to make money. Like Google, when it discloses, there is a revenue for that. So just telling the Google not to put that is a different issue. But a judgment is a legitimate fact of the society. It is the property of the society. It is not the property of the judge. It is not the property of the court. I don't think the judge should be given the right to say my judgment, I will allow certain things to be published, certain things not to be published. Okay, there is no such discussion. He is paid the salary from the government things, and whatever he gives as an output is a public property. Now the same question comes in the videographing of the court proceedings. Earlier, judges did not want public to see what they are doing. Now they have come down to accept that public have a right to view, though even now perhaps something they would like to have in camera, something they will exercise a discretion that only certain cases will be done under video conferencing and other things. But as we go forward, we should say that court is a servant of the public. Okay, and their decisions I have the right to know. Yeah, Prakash.
Yeah, Navi sir, so just to answer to what Subbaraidu was saying and also this discussion, you see, in most of the cases where we fill up forms, whether it is for a passport or visa or even for employment, the question that is asked is, have you been convicted by a criminal court? It's basically conviction. So acquittal is never considered as a bad per se. So
Correct.
yes, people may carry a biased mind that, if this guy has gone to court or he has been charged, that means maybe he is a bad guy or something. That's a different story. But actually, if you look at paper, it's only conviction which matters, number one. Number two, I'll just give you a live example. We have a running case, where a guy had actually, defrauded a lot of employees, about 300 of them, and used their passport visas. It is there in the public domain. That's why I can tell that. And then, took money out of, did a lot of fraud of foreign exchange dealings. And when that guy was almost going to be caught, he jumped off a 7-story building and killed himself. So the guy who did the fraud is no longer there. So what happens? The company which got defrauded has to catch hold of some company. Obviously, they caught hold of our company and they filed a case against us. We are fighting, saying that, whatever has happened was outside the scope of employment. It's going on. But the sad part in the whole thing is these 300 employees whose names are there, they are also party to that suit. And, civil suits, how it is. At least I have been handling this for the last 7 years now. And I'm sure it will continue for another 10 years. Okay, so now one guy recently reached out to us saying that, and what we have done as a company is, we have said that all these 300 guys, of them, maybe only 50 odd guys are still working with us. 250 have already left and gone. But we have assured them that because it has happened while it is here, we will take care of your defense. So that thing is being done by us. So all these guys know, and since I was handling it, these guys know that I am the contact man so long as I am here. So one guy who had actually left the company and he had joined another company, and now he was moving to a third company. This third company background verification team somehow found out that, this guy's name is there in an XYZ code.
Yeah.
And they were creating problems to give employment to him. So he reached out to me and said what to do. I said, no issues, because first of all, it's a civil suit. It's a civil suit for recovery of money. It's not even a criminal case against you. And you sent your, and we have the portal where external employees can seek, the relief from HR and all that. I told him, you apply in that portal, we'll gave him the link. And then we had an internal discussion and all that, and gave him the appropriate letter so that he could give to his future employer, to tell them that, that he is not involved. And even if it is there, it's the company which is defending. And then he got his job. So there are ways and means. It's not that, it will put a person down just because his name is there in the public domain. Yes, like this guy also had to go through this hardship. Maybe I'm sure he must have had this tension, whether I will get this job or not. It must have been paying him some extra money. That is there. So that is something which, it is unavoidable basically because of the mindset. Otherwise, if somebody had done a research properly and realized that it is only a civil suit and not a criminal suit, they should not have even pushed him to that extent.
Yeah. So we can sympathize with them, but I feel the law should hold its ground and say that right to forget should not be applied at places where there is a public interest involved. And hopefully one of these cases, when it goes to Supreme Court, a decision will come by that. Okay. Now,